Have you ever stopped to think about where Canada's criminal laws really come from? I mean, it seems simple on the surface, but the actual story, it's this amazing tug of war between judges and politicians, a really strange peeping Tom case that changed everything, and a huge constitutional showdown over our safety. In this explainer, we are going to unpack that whole fascinating story.
Okay, let's just jump right in with the big question. Who actually gets to decide that a certain behavior is so wrong it should be a crime? Is it Parliament sitting in Ottawa writing down laws? Or is it the courts, reacting to new problems in society as they pop up? Well, the answer is a little more complicated than you might think.
So in Canada, our law really flows from three different streams. First, you've got the Constitution. That's the ultimate rulebook. Then we have statutes, things like the Criminal Code, which are the laws written and passed by Parliament. And finally, there's the common law, which is basically this massive collection of rules built up over hundreds of years from judges' decisions. But here's the thing, and it's a really important thing. They do not all have the same power when it comes to creating new crimes. In fact, one of the most fundamental principles of our entire system was set up to make one thing absolutely clear. Judges are here to interpret the law, not to just invent new crimes out of thin air. Now, it wasn't always like this, and the story of how we got to this point is pretty cool.
It all kind of exploded in 1950 with this case about a peeping Tom. A man named Frey was caught looking into a woman's bedroom window. Another guy, Federoch, actually detained him, and his argument was that even if peeping wasn't a specific crime in the books, it was so offensive that it was bound to cause a disturbance, a breach of the peace, so it should be treated like a crime. Well, this whole mess landed in front of the Supreme Court, and they had to answer a huge question. Can something become a crime just because a judge decides it ought to be?
The court's answer was a loud and clear no. Their decision was a landmark, and it made it absolutely plain. Making new crimes is a job that belongs only to our elected representatives in Parliament. The courts are not supposed to be the morality police for new kinds of bad behavior.
And this wasn't just, a good idea they had. It was written right into our law. Section 9 of the Criminal Code is the final word here. It officially gets rid of what are called common law offenses. And that's a huge protection for all of us. It means you can only be convicted of a crime that is clearly written down in a law passed by Parliament. No surprises. But okay, here's a really interesting twist. While Section 9 got rid of common law offenses, another section of the Criminal Code, Section 8, specifically keeps common law defenses. So what does that mean? It means that while a judge can't make up a new crime, they can recognize and even develop defenses, things like necessity or duress or entrapment that aren't actually written in the code. It's this fascinating balancing act between limiting power and still allowing for fairness. So, if we've given all the power to create criminal laws to Parliament, what's to stop them from making laws that are just unfair or unjust, or laws that trample all over our basic rights? Who keeps the rule makers in check?
Well, the answer to that question showed up in 1982. It was the Canadian Charter of Rights and Freedoms. And this one document completely changed the power dynamics of our entire legal system.
This is where the Charter steps onto the stage, basically acting as this constitutional shield for our rights. And it's not just a friendly list of suggestions. No, it's the ultimate rulebook that even the lawmakers in Parliament have to play by.
The Charter's power is just immense. Because it's the supreme law, it puts hard limits on what Parliament is allowed to turn into a crime. And, this is key, it gives the courts a brand new and super important job: to be the referees. They get to blow the whistle when a law crosses a line and violates someone's protected rights. And if a law is found to be unconstitutional, the courts have the power to just strike it down.
One of the most powerful tools in the Charter's toolbox is Section 7. It guarantees our right to life, liberty, and security of the person. Basically, it means Parliament can't pass a criminal law that puts people's physical safety at risk in a way that's just arbitrary or way too broad or completely out of proportion.
Okay, so how does this actually work in the real world? Honestly, there is no better example than the huge 2013 Supreme Court case, Canada v. Bedford. This case put the whole system to the test. In the Bedford case, a group of sex workers argued that even though selling sex itself wasn't illegal, a bunch of other laws made it impossible to do it safely. For example, laws made it illegal to work indoors, to hire any kind of security, like a driver or a bodyguard, or even to properly screen a client on the street. Their argument was that these laws were a direct violation of their Section 7 right to security of the person.
And this really gets to the core of the whole legal fight. The government said the goal of these laws was to, prevent public nuisance and exploitation. But what was actually happening in the real world was that the laws were making sex workers more vulnerable. They were being forced into isolated, dangerous situations where they couldn't take even basic safety precautions.
In the end, the Supreme Court of Canada agreed with the sex workers, and in a really powerful statement, the court said, sure, Parliament can regulate things to prevent nuisances, but it can't do it by sacrificing the health, the safety, and the actual lives of the people involved.
So the court found that the harm these laws caused was, and I'm quoting here, grossly disproportionate to their goal. The damage to the safety of sex workers was just too high a price. So, playing that role of referee, the court struck the laws down. They were unconstitutional.
All right, so let's zoom out and look at the big picture here. What we have isn't just a dusty old set of rules. It's a dynamic, living system of law. It's a really carefully designed system of checks and balances that's meant to change and evolve with the times.
So this is our system in a nutshell. You've got Parliament as the one and only rulemaker for criminal law. You have the Constitution, especially the Charter, as the ultimate rulebook that draws the lines they can't cross, and then you have the courts, who are the impartial referees, making sure that the rulemaker always follows the rulebook.
So what are the big takeaways here? It's this. Only Parliament can write criminal laws. The courts can't make up new ones, but they play this incredibly important role as referees, using the Charter of Rights and Freedoms as their guide. And all of this makes our legal system a living, breathing thing, one that can be challenged and one that can be changed when a law, no matter how good its intentions, ends up causing real harm. And that kind of leaves us with a final thought. The Bedford case proves that our laws aren't just set in stone. They are shaped by people who have the courage to stand up and challenge them. It shows that our system can evolve to protect people. And so the question for us is, what's next? What principle out there today do you think is worth fighting for?